I'm Patricia DeFonte. I'm your little dark storm cloud, and I'm here to remind you that you're going to die. But before you die, there is a load of paperwork that you need to do. And one of the things that you absolutely have to address is your right of publicity. With me today is Owen Seitel. Owen is a partner at Crown LLP and one of the master practitioners when it comes to the right of publicity. He has experience helping clients while they're alive, addressing those rights, but he also has experience, let's say on the back end, after someone has passed away and assisting an estate in monetizing that right for the benefit of the named heirs. Thanks, Owen, for your time today.
Great to be here with you.
So I've said right of publicity a couple of times. Oh, and we have to say, we're both California lawyers, so we're going to speak California. You should check with a lawyer in your jurisdiction to see how it works where you are, because this is not something that's nationwide, and this is not baked into any federal codes. So, Owen, what is the right of publicity?
So, put simply, the right of publicity is the right to control the commercial exploitation of your name, image, likeness, and other elements of your persona. It could be your signature, could be your voice, so on and so forth. So, you have the right to control the commercial exploitation of that. Of your image and other elements of your persona. So that's basically what the right of publicity is.
There are some fun cases around the right of publicity. Somebody tried to do, I think, a commercial with a robot that was turning letters, and the judge said, everybody knows that that's Vanna
Vanna
White.
White. Yes.
There was another one where they tried to hire Bette Midler to sing about, I think, Doritos.
Correct.
And Bette Midler didn't want to sing about Doritos.
Right, right.
And what happened
So they
there?
hired her backup singer, who could sound exactly like Bette Midler, and she sang about Doritos. And of course, that was a nationwide campaign, and Bette Midler was not happy about
happy.
it. And she got a few dollars as a result.
So it's pretty broad. The courts have interpreted this right pretty broadly, that nobody can use you to go and make money.
That's
without
right.
your permission.
And one of the common misconceptions is that only celebrities have a right of publicity, and that's not true. You and I, even though we're not celebrities, Patricia, have a right of publicity.
Not yet. We're not celebrities yet.
We're working on it, maybe as a result of this video.
Yes.
One of the kind of classic examples I give, and I think, and this actually happened, a gentleman lives in a suburban neighborhood. He's a coffee roaster. And he roasts coffee and he puts his coffee in beautiful bags and so on and so forth. Well, he noticed that every day his neighbor across the street comes out of the house to walk down the lawn to get his newspaper. He's disheveled. He's got his bathrobe on. It just, clearly just rolled out of bed. Snaps a picture of him without his knowledge and slaps it on his bags of coffee beans. So that gentleman, whoever it was that would walk down his driveway in his bathrobe every morning, he had the right of publicity. He can bring a claim and he can get substantial damages as a result. So
but the statutes are friendly to the person whose rights have been infringed.
The California statute is very friendly. It allows for statutory damages. It allows for you can recover your attorney's fees under the statute, and you can get punitive damages under the statute. So it's from a plaintiff's attorney's side, it's a wonderful statute. As they say, it's these kind of claims kind of run on rails, as they say. And you're in a very good position if you do have to bring such a claim.
So for any of my business owners, clients out there, anybody who owns a business, if you're listening to this, please do not just take pictures of people and use their photos on your social media, in your advertising, on your website, on your swag. Don't do it. You are infringing that person's right of publicity.
Yeah, and I can tell you, Patricia, that where it often comes up is a business will have a social media team. And there's numerous cases where this comes up, but a classic example occurred, I don't know, maybe 5-7 years ago. The actress Katherine Heigl a photo was taken of her outside of walking out of the Duane Reade drugstore in New York with the bags that have Duane Reade all over them. Social media team gets the picture. Well, that's gold for them. So they slap it up. And hey, look who shops at Duane Reade. Well, that was a violation of her right of publicity. They're using it to market that particular establishment. She brought a claim and she did, pretty well with that, as I hear.
Well, celebrities, they're not just like us because they have excellent teams of lawyers, know the laws, and will come after you.
That's right.
So, Owen, what happens when you die? Does your right of publicity die with you?
Well, so first of all, taking a step back, the right of publicity is entirely a creature of state law. There is no federal right of publicity. There's periodically discussion about it, and there has been some heated discussion about it in light of AI and so on and so forth, but it remains an entirely state law. Right now, there's about 30 some states that recognize the right of publicity. Some 20 some of them have a right of publicity statute. The other 10 or so recognize the right of publicity by common law. So you have to look at, the law in your state. It's different. So in California, we also, in addition to the right of publicity for those that are walking amongst us, we recognize the posthumous right of publicity. So that is, the ongoing right to use the image of an individual for commercial purposes. So in California, that right lasts 70 years post-death. The difference is for the posthumous right of publicity, you need to be, and what the statute says, a personality at the time of death. So in other words, maybe you and I don't have a posthumous right of publicity, at least not yet. We have time to work on that, Patricia. But so you need to be somebody whose right of publicity has value at the time of your death. So, it doesn't need to be Johnny Carson or some, big star or anything. But if you can point to the fact that during your life, you exploited your right of publicity, maybe you did an endorsement or sponsorship deal for a company here or there, then you can establish that actually at the time of your death, you had, you were a personality and you're thus entitled to the posthumous right of publicity. Once you get over that hurdle, then in order to benefit from the right of publicity statute in the state of California, the posthumous right of publicity statute in the state of California, you have to register that right with the California Secretary of State. And if you go to the California Secretary of State database, you'll see something called a successor in interest registration, which tells you nothing, of course, but there you will see all the people that have registered their posthumous right of publicity. They're typically celebrities. And if you are a trust and estates attorney and you're representing somebody that has some level of notoriety, I would say you're obligated to register their right of publicity. You know what it costs to register that right of publicity in the state of California, Patricia?
It's either nothing or an insane amount.
$10.
$10.
Right in the middle of that wide range of numbers you gave me there. So there's the point being, there's no reason not to go ahead and register the right. Even if you're not certain that the individual that just died would meet the definition of a personality during their life, I would say there's no harm in registering the right. You can have that fight later if it ever comes about.
So if we're working with authors, photographers, drag queens, comedians, actors, influencers, it's an important right to preserve.
That's right. Those are all, I would consider all of them personalities under the statute.
So I know that you've worked with a few trust administration lawyers on settling the estates of people who did have a right of publicity, who were either famous or infamous. Can you, we learn best by the stories. So
Right.
Can you share a story with us?
Well, let me just kind of talk about, so yeah, if you're working with somebody who is a personality, obviously you have to point out, hey, you have this right, we have to deal with it. It is a descendable right. You can contract it away, you can deal with it in your testamentary documentation. One of the things you need to think about is if you're going to have somebody manage this right after you're no longer here with us, you want to name somebody that knows what they're doing in this particular area. So the people that you name as your heirs and to handle your estate, they may not be the right people to handle this particular matter. So the first question I would ask anybody is, who would you want to manage this? Who is capable of managing this? So that's step one. The other thing to keep in mind is you can contract away this right during your lifetime. So it's just like any other intellectual property right, being a copyright, anything like that. You can contract it away, so on and so forth. You can also add conditions or restrictions on the use thereafter. Common restrictions being, you will not use my right of publicity in relation to alcohol products, tobacco products, perhaps cannabis products for some people. Another common one is feminine hygiene products, and so on and so forth. There may be things that you just don't want your right of publicity associated with, or you could do it in a proactive way and say, the only scenario that my right of publicity can be used after I am dead is with regard to animal rights and welfare organizations, something like that. That's a common one. So that's the most important thing. I've dealt with situations where we've got a celebrity that dies that names, perhaps your surviving spouse and maybe one of their kids as the administrators of their estate. And you know what? They did not have the wherewithal to handle that. And it really should have been, he should have named his longtime manager, who, was with him and knew him very well and knew what he, was all about during his life. That person should have been named. We got there. It required a little bit of maneuvering and probably more attorney's fees than was necessary. But we get there. But throughout the whole time, I just thought, during this celebrity's lifetime, if they would have just given some thought to this, if their attorney would have said, "Hey, think about this," they could have contracted that right over to their manager and added whatever restrictions they want, no alcohol, tobacco, whatever it may be, and leave the rest of their estate to the family and, the surviving spouse, let them deal with, the real property, whatever else is involved there. So that's where things typically kind of go haywire in this area. And the other problem is just not registering the right with the Secretary of State. Because if you don't register it, you can't bring a claim. And then you're, kind of SOL, as they say.
Yes, we always love any statutory right that comes along with attorney's fees, because that means that a lawyer will take the case. Otherwise, you have to prove up, oh, well, I was damaged by this in the following ways. By the time you're done paying all the experts, well, there's
Right.
no money to pay the
Right.
expert.
And the
So,
beauty of the California right of publicity statute, and this is true of both the right of publicity statute and the posthumous right of publicity statute, is you can opt to prove your actual damages, which can be hard. I mean, if it was you or I, Patricia, we have no basis to, say, well, this is how I was damaged because they use my image. So you can opt instead for statutory damages, which the statute allows. And the statutory damages are a minimum of $750, which is not huge or anything. But once you get that, then you can turn around and say, and I want my attorney's fees. And that's the big hammer, because obviously you're basically saying to the person that breached your right of publicity, hey, buddy, you're not only going to pay your attorney, you're going to pay mine too. And the longer this goes, the more
worse
expensive
it's going to
it's
be
gonna
for
get.
you.
That's right.
Yes.
So it behooves you to make a very reasonable proposal and be done with this as soon as possible.
I'll say that, so I have you and I worked together for many years. I have a background as a copyright litigator and also as an entertainment lawyer. And the right of publicity was always my favorite. And I absolutely love including it in my estate plans. It's something that we address for many of my clients. And the way that we address it within the documents can be different. Sometimes the instruction is, I want my entire archive destroyed. I'm leaving it to my best friend. I don't want my unfinished manuscripts out there. And, normally they might leave that kind of stuff to a surviving spouse or to their kids, but they trust their best friend to actually destroy. And actually, recently in the news, Gabriel Garcia Marquez had an unfinished novel, and he told his children, do not publish this, and they ignored him.
Right.
And so who's going to stand up for him? No one. That's it. And so what we can do in writing is one thing, but the decisions that the client makes are really, really important. How do we structure the documents? How do we structure this plan so that we're actually giving the right people the authority to act for us, who are actually going to respect the things that we're telling them? Most clients want to leave their right of publicity and their archives to museums, nonprofits, cultural institutions. But every once in a while, there's a client who has really young children. What they want is they want monetization.
Mm-hmm.
They want to make sure that their children are going to benefit not only from the art that they've created, that they've put out into the world, but by the use of their name. And sometimes they want to support a business. It's an incredible thing for a pretty well-known comedian to leave their name to the comedy club where they got their start. And maybe that comedy club isn't attracting anybody anymore. But if they leave them the name and a little bit of money, maybe that just turns everything around, not only for that business, but that entire local community of comedians.
Sure.
And so it seems like, oh, it's just my name. Your name has value.
Tremendous value. And as somebody that does a fair amount of sponsorship and endorsement deals, look, there's Jennifer Aniston. She has an endorsement deal with Smartwater. She has a very valuable right of publicity. There's a big number attached to that sponsorship and endorsement deal. Then you've got, these days, if you're a college kid, you can sell your right of publicity without violating NCAA bylaws. And that may be nothing much more than going down to the university sandwich shop and getting a sandwich named after you, which is wonderful. I'm not going to diminish, that at all. So it's a broad range, but the bottom line is it's a right. It has some value. For some people, it can have tremendous value. And that needs to be taken into consideration with all the other property you're dealing with in your estate. You need to distribute that, get it in the hands of somebody that can, deal with it professionally.
For me, a horror story of this failure to plan. What I keep seeing are Jean-Michel Basquiat's, his artworks. It keeps popping up on my social media feed where they're taking his art and they're putting it on doormats, front doormats.
Right.
Please, please, estate planning for my artists and creators out there who are watching this. Some clients say, oh yeah, I don't care if they take all of my artwork and put them on shower curtains and sell them at the big box stores. If that helps provide for my family, that's wonderful. The other half say, I can put a restriction on that. I don't want that. My art is my art, and it is not to be used as doormats and umbrellas, et cetera, et cetera, et cetera. If he had left his right of publicity to a museum and said, in order to fund the operations of the museum and to support certain types of artists, however he wanted to say it, and they were selling those items, maybe it's different. Although I would take offense at a museum who would do that. Like, really? Where people wipe their feet? It makes me really angry.
Oh, come on, Patricia. When was the last time you were in a museum gift shop? It's embarrassing.
It is embarrassing. Usually it's t-shirts. T-shirts. Owen, thank you so much for your time today. The right of publicity is not easy for people to wrap their heads around. And we really want to make the point that if you're even a little bit famous, this is something that you could help your family with it. You can help an entity, a nonprofit, a business that you really enjoy and love and support. And at the very least, you can stop someone who doesn't care about you from using your name in a way that you find deeply offensive.
Well said. Agreed. Great to be with you, Patricia. Thanks for having me.
Thank you, Owen.
All right.